Hi everyone, this is Atty. Nikki Vega, Managing Partner of Nicolas and the Vega Law Offices, and welcome to our YouTube channel. I understand right now many businesses are experiencing losses due to the quarantine. You know, the community quarantine in Metro Manila has restricted, indeed, the movement of people in the city. So you could see the closure of companies during the quarantine, and ultimately, this would really have an effect on both businesses and the labor force, most especially to those enterprises deeply affected by these quarantine measures. Sadly, this could lead to the closure of some businesses and the loss of jobs. But for others, there is a glimmer of hope in the continuity of their businesses, but certain measures must be implemented to keep the company afloat. So if alternative work arrangements or remedial measures are insufficient, companies have to make the painful decision to lay off or retrench employees to save the business. No less than the Labor Code recognizes retrenchment as a right of the management to meet clear and continuing economic threats during periods of economic recession to prevent losses. Say, for example, in the case of Waterfront Cebu City Hotel versus Jimenez, the Supreme Court had the occasion to define retrenchment as the termination of employment initiated by the employer through no fault of and without prejudice to the employees. It is resorted to during periods of business recession, industrial depression, or seasonal fluctuations, or during lulls occasioned by lack of orders, shortage of materials, conversion of the plant for a new production program, introduction of new methods or more efficient machinery or automation, or this COVID-19 pandemic. It is an act of the employer of dismissing employees because losses in the operation of a business, lack of work, and considerable reduction on the volume of his business. Now, in case you are thinking about pursuing retrenchment, let me walk you through the legal procedure for retrenchment. In order to legally retrench employees, the following must be followed. First, retrenchment must be undertaken to prevent losses, which are not merely de minimis, but substantial, serious, actual, and real, or if only expected, are reasonably imminent as perceived objectively and in good faith by the employer. Second, the employer should serve written notices both to the employees and the Department of Labor and Employment, or DOLE, at least 1 month prior to the intended date of retrenchment. Third, the employer should pay the retrenched employees separation pay equivalent to 1 month pay, or at least 1/2 month pay for every year of service, whichever is higher. Fourth, the employer must use fair and reasonable criteria in ascertaining who would be dismissed and retained among the employees. And finally, the retrenchment must be undertaken in good faith. It must be borne in mind that even if retrenchment is part of management prerogative, the requirements that I mentioned must be met to consider the same legal. Thus, the company must show that the expected losses are substantial, serious, actual, real, or reasonably imminent. This can be justified, say if the establishment is forced to temporarily close due to the community quarantine and the overhead expenses of the company cannot be met, such that to continue to employ certain employees would drive the company to close. Further, the books of accounts of the company must be able to justify such expected losses. In addition, it is best if the company tried to adopt remedial measures suggested by the DOLE before resorting to retrenchment. It should be a measure of last resort and done in good faith and not to undermine the employee's security of tenure. So that's it, folks. That is how legal retrenchment of employees can be implemented due to COVID-19 in the Philippines. I invite you to subscribe to our YouTube channel or visit our website www.ndvlaw.com to learn more about your legal rights in the Philippines. Good day.